If your board has ever told your management company, don't call the attorney without approval, you may have already made a decision that's quietly putting your association at serious legal risk. And the worst part, most boards that do this think they're being responsible. We get it. Legal fees are real. Budgets are tight. And when you see a bill from your association's attorney, the instinct is to tighten the reins. Make sure every call goes through the board first. But here's what most boards don't see. Your management company isn't calling the attorney because they don't know what to do. They're calling because they do know where a situation's headed and they're trying to get in front of it before it becomes expensive. By the time a board decides a legal opinion is worth it, the window to act early has often already closed. Your attorney is now playing catch up, and catch up costs more than preparation. The associations that face the largest legal bills are rarely the ones that talk to their attorney too often. They're the ones that waited too long. When a board systematically blocks its management company from communicating with legal counsel, something else is usually happening beneath the surface. Sometimes it's a trust issue, a board that doesn't fully trust its own management company's judgment. And if that's the case, that's a much bigger conversation than legal expenses. Sometimes it's a control dynamic. One or two board members who want every decision to flow through them, including decisions that are time sensitive and require professional judgment. Neither of those is a healthy structure for an association. Your management company's job is to act on your behalf, and that includes interfacing with your attorney when the situation calls for it. Removing that function doesn't protect the association, it exposes it. Here's what most boards never consider. If something goes wrong in a situation where your management company flagged the need for legal counsel and you blocked that communication, the board members who made that decision may own that outcome personally. Association governance involves real legal exposure, decisions about collections, construction defects, fair housing compliance, vendor contracts, and insurance claims all carry risk that a board of volunteers is not equipped to evaluate alone. That's not a criticism, it's just the reality of how complex community association law has become. Your management company understands this landscape in a way a volunteer board member, however well-intentioned, typically doesn't. They've seen these situations play out. They know what your attorney needs to know and when, and they know that getting your attorney up to speed early is always cheaper than damage control later. When you limit that communication, you're not saving money, you're transferring risk onto the association and onto yourselves. The question isn't whether your association will face situations that require legal guidance. Every community does eventually. The question is whether you have a management structure in place that can navigate those moments effectively, or one where the board is a bottleneck between your community and the professional help it needs. If you're not sure your current setup gives you that confidence, or if this is a conversation you've been avoiding, that's exactly when a conversation with us makes sense. At ManageMax, we know that effective community management is built on transparency and systematic excellence. We provide full-service HOA and condominium management across Southeast Michigan, handling everything from accurate financial reporting to proactive maintenance. Our goal is to reduce the burden on your board while protecting your property values. If you're looking for a partner who values accountability as much as you do, visit us at ManageMaxProperties.com. Let's build a stronger community together.